Well, welcome everyone to our Mississippi Law Journal Symposium, co-sponsored by the Law School and the Declaration of Independence Center for the Study of American Freedom. It's hard to imagine a more timely issue than this, just 3 days after a big oral argument in a Second Amendment case. Y'all are much too young. Some of you aren't young enough not to appreciate this joke, but back in the 80s, New Yorker had this cartoon, and there's this fellow obviously on a date, and he's holding up a big rifle, and the date says, "Wow, I've never met a Second Amendment lawyer." And y'all, of course there's Second Amendment lawyers. There's been a bunch of cases about the Second Amendment. Well, we have, I'm not sure all four of our panelists would call themselves Second Amendment lawyers, but it is a field that has lots of experts, and we have four of the very, very top ones. So in alphabetical order, I'll introduce them. Brandon Denning is the Starnes Professor of Law at Cumberland, and he has taught there since, I don't know how long he's taught there. He does summer stuff in Cambridge, which many of our faculty have done, which is a wonderful thing. He published in 2016, Guns and the Law, Cases, Materials, and Explanation, with Andrew McClurg. And he, just this year, or I guess it has a future tense. Has it come out yet, the 2023? Okay, so University of Kansas Press published The Advantages of Being Armed, the Second Amendment in American Culture, Politics, and Law, co-authored with George Washington professor Robert Cottrell. Next, alphabetically, George Moxary, who teaches at Wyoming. He also is co-author of a casebook on the Second Amendment, co-author of Firearms, Law, and the Second Amendment, Regulation, Rights, and Policy, which you can visit at firearmsregulation.org. Surely the casebook is not just online. Is it an open access book?
No, there's a printed version, and then there's an set of online chapters that are very large.
So enticing. So if you go online, you can sample some, and just like Taylor Grocery Catfish, you eat one, and you're like, I want the full book. So just the teaser online. Next we have Fred Vars, who teaches at Alabama, who has written a heck of a lot of articles about many things, but a number of them about the intersection of mental illness and disarmament, which is one of the issues, not in the Rahimi case, but in the wake of Bruen. A number of the challenges have related to exactly when the states and the federal government can disarm people based on mental illness. Including Do the Mentally Ill Have a Right to Bear Arms from 2013, going through the then prevalent tiers of scrutiny approach to the Second Amendment, which we discovered in Bruen was not the way to do it. And then finally we have Andrew Williger, who teaches at Duke. He's the executive director of the Center for Firearms Law, and he has appeared just about everywhere in the media. He teaches a class on Second Amendment history, theory, and practice. So, well, it's interesting. We have this panel today. Just last week, I was revising I am a co-author on a casebook series, and the lead guy, I'm not the head honcho on the group, but the head honcho said, there's enough Second Amendment law. So we have like a 6-volume thing. So we've got one on interpretation, one on executive power, one on extent of federal power, one on dormant commerce clause and stuff. Brandon, by the way, is one of the world experts on the dormant commerce clause. And then my big one is the 15th Amendment, 14th Amendment, and then we've got a First Amendment. So, but Lee, my co-author, said, hey, we should, how about adding the Second Amendment to your 14th Amendment book? And I'm like, my 14th Amendment book is huge. You should add it to your book on the nature of interpretation. Use it as a case study or something. But I said, okay, Lee, I'll add. So we were just doing this revision, and I So I said, I'll add a meaty paragraph summarizing what's going on in the Second Amendment to the 14th Amendment when I talk about tradition. And it turns out I told the panel I would briefly summarize, briefly set the scene. Why is the Second Amendment after Bruen a thing? Why is something we worry about? So here's what I said in our casebook. Tradition has been extremely important to several other areas of constitutional law besides substantive due process. Second Amendment law is a particularly prominent recent example. In D.C. versus Heller from 2008, the court held that the Second Amendment protected an individual right to keep a handgun in one's home. The court looked at tradition to measure the scope of the right. Quote, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. The footnote added, we identify these presumptively lawful regulatory measures only as examples. Our list does not purport to be exhaustive. The court also looked to historical tradition in limiting the Second Amendment to arms in common use. 2 years later, the court in McDonald in 2010 reaffirmed this limit on Second Amendment as applied to the states. However, following Heller and McDonald, lower courts evaluated gun regulations using intermediate scrutiny means-ends analysis, but the court repudiated that approach in favor of tradition in New York Rifle and Pistol Association versus Bruen in 2022. The government, this is what the court said, must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms, close quote. The court did not specify what date was critical for this analysis of tradition. 1791, when the Second Amendment was adopted, 1868, when the 14th Amendment was, or today. One important fact for Justice Kavanaugh's concurrence, joined by Chief Justice Roberts, was the fact that 43 states allow public carrying of firearms without a special justification. The court in Bruen held that a categorical ban on carrying guns in public was not supported by such a tradition. Bruen led to a flurry of litigation in the lower courts applying the new standard. The Fifth Circuit held that 18 U.S. Code section 922G8, imposing federal criminal liability on gun possession by those subject to a domestic violence restraining order, was not supported by a sufficiently robust tradition. In the U.S. versus Rahimi case from earlier 2023, the Supreme Court granted review. That's how it'll appear in my casebook, which I won't have time to wait for Rahimi. But we'll get the panel's take on Rahimi and what are the other things going on since Bruen. Did we talk about order? I think alphabetical order works perfectly. That's the head honcho on my casebook. He's last alphabetically. We put him last on the casebook, even though he's in charge. So why don't we just do it alphabetically? Okay. If Brennan's ready to kick it off.
All right. Well, thanks. Thanks, Chris. Thanks, Will, for putting this on. Thanks to my fellow panelists, and thanks to all of you all for hanging around on Friday. I guess you could say in the lower courts, troubles brewing. All right, good. That's it. Thanks. No, seriously. There are a number of odd things about Bruen. This morning I was reviewing the oral argument transcript in Rahimi, and it's clear that the court has painted itself into a corner. Bruen was odd on a number of scores. Most notably, and the biggest mystery, and I'd be interested if anybody had any thoughts on this, is why in the world Chief Justice Roberts assigned the opinion to Justice Thomas. He had the choice, and Thomas delivered an opinion that not only laid waste to 15 years of lower court litigation, but also created a test that nobody quite knows how to apply. And it's clear that the court itself really doesn't have any idea. So, Rahimi, if you think about it, Bruen came, 12 years after McDonald. And of course, the court realized almost immediately that it was going to have to do some cleanup on aisle 3, particularly after the Fifth Circuit, said that you can't bar people who are subject to domestic violence protection orders from possessing firearms. Almost certainly, I would bet almost any amount of money that the Fifth Circuit would be reversed. I actually wouldn't be surprised if it were unanimous. And it's clear.
At what odds, though? So I'm always telling my kids. My kids say, "I bet $1 million that something," but what odds?
I don't know. I mean,
at least 95%.
Yeah. I mean, 95%. It would really shock me. So what are they going to do? And I just don't know. I don't know whether they're going to say, well, we were talking to law-abiding people, if they're going to rely on the Heller safe harbor and say, well, we had those categories of quote-unquote long-standing. Or if they're going to maybe try to refine that history of tradition test and at least specify what level of abstraction lower courts have to operate when trying to look for the historical analogy. As I say in a paper, it's like the old, the old proverb, right? As the dog returns to its vomit, the fool returns to its folly, and I think that that's what the court's doing right here.
George. Okay. No. What? Yes. Okay. You're next.
So thanks for giving me extra time there. I got just all that 10 minutes and we go about 12. But so I'd like to get into a little bit of detail about Bruen here. I'll start by talking about, well, a little bit of what came before Bruen, expand on that 15 years or so of jurisprudence that came then, what courts were doing there. Then talk about Bruen and the rules that we get from Bruen and why I think we might have gotten those rules. Excuse me. Then I'll talk about where I think they'll work and where they won't, and then some speculation on what we might see going forward. So Bruen challenged New York's May issue carry licensing regime. And for those who don't know, though I suspect here a great many of you do know, as in Wyoming, under a shall issue concealed carry licensing system, the state issuing authorities have to issue you a license to carry in public. If you're not a criminal, insane, you take a safety class and do some basic things. After a background check, you'll get a license to carry. New York, and it was one of about 6 states where licenses were issued on a May issue basis. And so the main question in Bruen was whether these kinds of licenses were valid. And so under New York system, to quote New York courts, an applicant had to, quote, demonstrate a need for self-protection distinguishable from that of the general community or persons engaged in the same profession, end quote. Another quote from a different case there, a generalized desire to carry a concealed weapon to protect one's person and property does not constitute proper cause. That was New York. That's what if it's for me, I'm not here. I'm sorry, I do that to my students all the time. Before Bruen, and after McDonald, so Heller said in 2008 that the Second Amendment protects an individual right to own a handgun and also a long gun. That part's often left out. Heller also struck a law that said that you had to keep a long gun in D.C. disassembled, essentially, right? So that's illegal. So firearms for self-defense, they had to be usable. And McDonald applied it to the states, and then the lower courts started hearing these cases. And all of them were applying something called the two-part test, that came to be known as the two-part test, to any kind of gun regulation that came out. Every circuit except, I think, the 8th adopted that test. And so the way that test worked is first the court would ask, is this conduct, is this thing that the law bans within the scope of the Second Amendment? If it wasn't within if the court said it wasn't within the scope of the Second Amendment, the case stopped and the plaintiff lost. If it was within the scope of the Second Amendment, then courts would apply some form of heightened scrutiny, based on how close it was to the core of the right. If you're thinking that's glaringly circular, you're right. But it was almost always intermediate scrutiny, right? And the courts under this test were upholding almost every law that came their way, right? They would do it with analysis that wouldn't fly in any other area where intermediate scrutiny or any kind of heightened scrutiny would apply. And sometimes they did it with quite a bit of what you might call vitriol or harsh words or hatred for the Second Amendment, guns, gun owners, Heller, these kinds of things. Right? So many people, myself included, wrote and spoke and talked about, and including at least 4 or 5 Supreme Court justices in dissents from cert denials, would say that the Second Amendment is being treated like a second-class right. Okay, so then we get Bruen, right? Then the court grants cert in Bruen. And so the two big questions were, against this backdrop, first, whether means-end scrutiny would apply for the two-part test that I just described that was adopted, again, by all but one circuit. And if it did, how strong would it be, right? And then second, how would history be handled, the history that we heard about in Professor Green. So here's what we get from Bruen. I'm going to give you some black letter issue rules. So the core rule is that discretion in who can exercise the Second Amendment right is not allowed. So, quote, we know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need, end quote. Means-end scrutiny and the two-part test, both are gone. The court did away with it. So judicial interest balancing is not allowed. And in corollary to that, explicitly stated in Bruen, which is a thing that it actually, the court explicitly said that, is that the judiciary may not defer to legislative interest balancing. And relatedly, the burden of proof is on the government. That when a plaintiff asserts a Second Amendment challenge, the burden is on the government to prove that its law is constitutional. And so I think this turned out the way it did because lower courts were, as I mentioned, so brutally abusing means-end scrutiny to undercut the right to keep and bear arms. Had they applied heightened scrutiny in any kind of meaningful way, any way that had meaningful teeth, I think the construct would have actually survived in the Second Amendment context. Because before Heller, all of us on the gun rights side were talking about the Second Amendment in heightened scrutiny terms. Strict scrutiny, intermediate, admission, fail, where, and so on. And looking at Bruen, why does the court have to say so explicitly that the burden's on the government? After all, the burden of proof is supposed to be on the government, right? Even under tiered scrutiny. It very often wasn't administered that way. I can't tell you how many times I've seen opinions say the plaintiff hasn't shown. No, the plaintiff doesn't have to show. The burden's on the government. The question should be, has the government shown? So the court did away with the second part of the two-part test and made explicit, as should be the case with constitutional rights, that the government bears the burden. So in other words, this is the court, the Supreme Court asserting its authority. So what's the core test there? Text as informed by history, text, history, and tradition. Sometimes it's called a THT. So when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And so far, that's nothing special, right? So if you're in a restaurant and you file a Fourth Amendment claim saying that police officer was staring at me, you don't have a Fourth Amendment claim. Someone staring at you in a public place is not a search, not a seizure. Right? Okay, so then, once we've gotten past the text stage, the government has to justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearm regulation, right, as we heard. And so how is history applied? How do we use this history? Well, it wasn't me, maybe it was.
No, it's feedback, so you need two. So
right. I can talk to both at once and hear the room.
Yeah, I believe my microphone. You
So how is history applied? It's by analogy, right? The court goes into this in some detail, laying out basic rules on analogizing. And one might ask why, and I think it's an attempt to head off more defiance of its Second Amendment rulings. I think that the court's analogizing can be boiled down to what are referred to as, quote, at least two metrics, how and why the regulations burden a law-abiding citizen's right to armed self-defense. So I think the why, which the court defines as, quote, whether that burden is comparably justified, is the more interesting and important one. And I think the negative aspects of the why will come into play from two angles. So first, it prevents historic burdensome laws that were enacted for one purpose from being used as the basis to impose burdens for other purposes. So, for example, one attorney for a gun control organization wrote the following: militia and fire prevention laws impose substantial burdens on founding-era gun owners. And he believes that courts should uphold similar burdens, quote, regardless of the underlying motivation for the regulation. So that's one. Second, I think the why part will cause historical restrictions passed for later unconstitutional reasons to face a greater hurdle in their justification. And the great example of those are the ones that Brandon's co-author Bob Cottrell has written about. The early gun control laws after the Civil War banning all but expensive military revolvers, which were passed for the racist reason that freedmen wouldn't have gotten them from past military service, obviously, and they couldn't afford them because they were very expensive. Okay, so how will the test work? So I think where there's a good body of law, a good body of common law and statutory law on the given aspect of arms bearing that the challenge regulation deals with, it'll work well. So on public carry, it was very easy. We have a great deal of general law, to use the phrase from Erie, right? Your Erie Railroad on public carry. We have statutes. We know what courts upheld, and we know what courts struck from the time of the founding and the time of the second founding, if you will, right? So we know what legislatures tried and what courts said about it. It'll have more trouble where there's no common law on the topic, right? In these cases, courts will have to decide whether the mere existence of a statutory restriction suffices if it wasn't challenged, right? It'll be hardest where there's neither type. And, for example, so in a so-called assault weapon case or a magazine capacity case, what do we make of there having been high-capacity repeaters in existence that could shoot very quickly, like the Girandoni rifle? The Girandoni rifle could shoot 22 rounds in 30 seconds, and each round could take an elk. So far more powerful than an AR-15, right? By a lot. And there was neither a legislative ban on the Girandoni rifle, nor was there obviously a challenge to the ban, right? So in those kinds of cases, courts, I think, will have to rely on first principles or something like first principles combined with precedent about the Second Amendment's purpose. So is the Second Amendment only about personal self-defense against criminal attack? Does the self-defense extend to protection from tyranny in its various forms, right? Does it have a military purpose? Is it about hunting? Does the Second Amendment protect hunting, right? So different answers to those questions can lead to different results in something like a magazine capacity case, right? Is this 20 or 30 round magazine protected? As to what will happen, I think defiance will continue. There are a few lines in Bruen, all of which are basic rules of interpretation, that I think will be hooks onto which hostile lower courts will hang their opinions. Just give you one example. Quote, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated, end quote. Right, that's a basic statement of what a Constitution has to do, right? There are others like that. I'll give you, so there was a very defined case from just a few days ago in the Seventh Circuit where the court adopted the reasoning of one of its prior opinions that said that a firearm that didn't exist at the founding wasn't protected because it didn't exist at the founding. Right, that happened in the Seventh Circuit. Legislatures are also being defiant. New York's Concealed Carry Improvement Act is a good example. It was passed after New York's governor sent something called a message of necessity, which is allowed by the state constitution. If you pass a message of necessity, or send one and enough legislators agree, you can circumvent's the wrong word because it's a constitutional provision that allows you to avoid another constitutional provision that the legislature, and the public for that matter, right, has to have 3 days to deliberate over proposed legislation before the legislature can vote on it. She and the legislators that supported her said that it was too urgent not to pass immediately. I thought that was an odd claim, given that the law wouldn't take effect for 2 months after that date of passage. A reporter asked, quote, "Do you have the numbers to show that it's the concealed carry permit holders that are committing crimes?" She replied, "I don't need to have numbers. I don't have to have a data point that this is going to matter," end quote. Or another reporter asked where people would be able to carry, and she said, quote, "Probably some streets." So the law is really problematic because the list of sensitive places is a term from Heller, is so vast that you essentially, all you can do is leave your home, not go to any destination, leave your home, spend some time on the streets, as she said, and then go back home. And in the process, you can't stop for gas, you can't go to the bathroom, and so on. It's that restrictive. Some parts of the law even apply to people in their private residences. Okay? Although the district courts have generally enjoined the more egregious parts of the law, and not only in New York, but most of the other states have copied this. New Jersey District Court and others have stricken them. The ones from the Second Circuit have been stayed by the Second Circuit. So if New York's law and its 2 copies stand, we'll get 2 ironies will result. So gun owners on the ground in New York, and the same is true in California and Massachusetts, and at least those 3 states, will be much worse off than they were before Bruen. So why is that? So in New York, California, and Massachusetts, issuing authorities in the vast majority of the states, in the vast majority of the counties in the states, even though the state was a may-issue jurisdiction, would issue licenses on a shall-issue basis. Right? So New York City, Long Island, Ithaca would issue on a may-issue basis. And may-issue, by the way, really means you're a retired police officer, the spouse of a police officer. Aerosmith, Aerosmith, the rock band, got its concealed carry licenses in New York at one police plaza during the day. That night, limousines picked up the issuing officers and took them to the Aerosmith concert in Madison Square Garden. I'm thinking the seats were probably ones that the rest of us lowlife scum couldn't get. So the may issue means special people who have connections get licenses, right? So now, in California, New York, Massachusetts, nobody can carry anywhere. Even the people who can easily get licenses if they lived outside of New York City, San Francisco, Los Angeles, etc. Now the people way out in northeastern California can't carry anywhere either, even though they could. So that's one irony. I think second, and maybe irony is a wrong word to describe this, I think if New York and its law copies don't get Supreme Court review, I think the Supreme Court's legitimacy will be in more distress than it ever was. So maybe I'll leave it there.
Okay, Fred.
All right. Thanks so much, everybody, for being here, inviting me, and so forth. I'm glad I didn't have to go first. It's very rare that someone with the last name Bars is not last on the night, so I appreciate your presence. So I'm going to focus on one little part of Bruen that we did sort of hinted at, but just one component of the reasoning. And that's the idea that if history and tradition is defined in part by legislative inaction. So the Bruen Court, Thomas, and the 5 other justices in the majority say, okay, the absence of a comparable or distinctly similar, different words, analogous gun provision at the framing or at Reconstruction is evidence that the legislature, those state legislatures, didn't pass that regulation because they thought it would be unconstitutional under the Second Amendment. That's how it's relevant, right? If the legislature doesn't do something, the only way that matters in terms of how we're going to interpret the Second Amendment, if that's setting part, if the history is defined by inaction, well, the reason the legislature didn't act must have something to do with the Second Amendment. So that's a kind of premise that comes out, and it's the easy case is the one you've got litigation, you've got provisions, you've got a record. But what do you do for domestic violence? There's no law disarming a domestic, somebody subject to a restraining order. Restraining orders didn't exist, right? So in the absence of kind of a historical record, it's really hard to figure out what the history and tradition was. And the sort of I've been bashing Bruen on this point, since it came out. had a piece in the LA Times about Rahimi and this issue. And Rahimi's a really good example, and I sort of suggested a second ago. You can't find a comparable statute in history. And the Supreme Court, in oral argument, wasn't asking, please show me a state statute, please. I don't remember any discussion of any state statute. The justices are looking around saying, wait a minute, we cannot give violent domestic abusers a constitutional right to have a gun. Surely, if the judge finds, issuing the order, this is a really dangerous person who shouldn't have a gun, well, that's got to be enough, right? Even though, again, no historical precedent. And the key in there, too, is it's not just that the law didn't exist, the problem didn't exist, right? So to the extent now additional historical research has happened, looking back at death certificates from the founding, how many domestic abuse cases, domestic homicide cases involved a gun? Very small percentage. Today, it's more than half, right? And part of the reason for that, this went on the LA Times thing, but you could store a gun generally. You didn't store guns loaded, right? Because the black powder is going to corrode them. Steel, it wasn't steel, I don't know, but metal, right? So you just didn't have a loaded gun sitting around. Guess what? A lot less, intimate partners pick up a gun and shoot their spouse. It just doesn't happen. So the problem didn't even exist. So the fact that the state legislature didn't enact a solution to a problem that didn't exist can't weigh, against that restriction, at least on the Second Amendment. So in the course of doing this research, and I'm new to this, and these guys, I'm glad I raised this the kind of thing I really wanted to get to today with them, because these are the casebook authors for the Second Amendment, right? So I'm just kind of a dilettante here. But the argument that struck me is, well, at the founding, is it reasonable to think a state legislature, maybe there was a problem that actually existed that had something to do with guns, right? And the fact they didn't address it, could the reason possibly be the Second Amendment? Well, at the founding, did any state think it was bound by the Bill of Rights? No. Did it happen at Reconstruction? Well, now we've got the 14th Amendment, so there's a textual argument there. But still, 5 years after the 14th Amendment went into effect, the Supreme Court expressly said it didn't incorporate the Bill of Rights against the states. That didn't happen until 2010 with McDonald. And in the meantime, and I know the reason I'm glad I talked about this, there are a few cases, I guess, where state courts said, we're going to do this because of the Second Amendment. I don't know why they were doing that before Reconstruction. To me, that makes no sense, right? The Bill of Rights did not apply against the states. That was hugely important. So I guess some courts were looking at it. But also, except for those 5 years, right, after the 14th Amendment goes into effect, legislative action during those 5 years, the states thought that was going to, incorporate the Bill of Rights, including the Second Amendment, against them, the states, the state legislatures. So maybe during that 5 years, the Supreme Court turns around and says, no, it doesn't incorporate the Second Amendment. So I don't know how anything the state did after that. They shouldn't have been thinking about the Second Amendment, right? And I know, maybe there's some historical regulation that's broader than the Second Amendment, and when you use that to interpret the Second Amendment, but you got to make a move like that. You can't really seriously consider, at least at the founding, that those state legislatures did anything because of the way they interpreted the Second Amendment, which they knew did not apply to them, right? It just makes literally no sense to me. And I know these guys will explain why it does. But then how much did I use that? Right?
Oh, goodness.
I'm good?
No, I think.
Okay.
By the way, the clock over there, I promised George we'd end by 2:15. That is daylight time, so it's actually 1:15. Lest anybody run off to think it's again. Tough release.
Yeah. So the one thing I'll mention too is that you saw the court struggling not really on this point. Everyone knew there wasn't a domestic violence gun law that they could hang their hat on to interpret the Second Amendment. But the justices were very excited, it seemed to me, to want to impose an exception for dangerous people, right? And at least even the lawyer for Rahimi at some point says, at some level of demonstrated dangerousness, you can disarm someone. Maybe that's not my case, maybe there wasn't enough process, right? But and the justices, I think, seem very amenable to that argument. A dangerous person, at some level of dangerous, they lose their Second Amendment right. The government can't actually take away a gun from somebody waving it in front of them, bang. Right? At some point, clearly, you don't have a Second Amendment right to bear arms anymore, right? You're really threatening public safety in a very direct and immediate way. And so I think that's how it's gonna play out. And I was really interested to hear the sort of why and the idea that that's going to remain relevant. I mean, I don't think the connection. You're dangerous because you're in an intimate relationship, and the data today show throwing a gun in there is going to kill the partner. So that's a different purpose, I guess, although at a level of abstraction. Maybe if you're dangerous enough in that way, that's similar enough to other prohibitions against other dangerous people that did exist. So that may be the way it goes. And one thing that I think is interesting, I wrote that paper about mental illness. Do people with mental illness have a right to bear arms? And one thing I will say about that is, and this is my actual area is mental health law, there is a misperception shared by Congress in 1968 that people with mental illness are, because of their mental illness, more dangerous toward other people. And it's just not true. The data do not support that conclusion. And I think that was the real motive in 1968 for passing that restriction. I hope we're not stuck with that motive. I think there's some suggestion that danger to self was considered. And if we need the purpose to be the same, that's critically important. Because mentally ill people, by virtue of mental illness, most diagnoses are at substantially elevated risk of suicide. Like, they are really, really dangerous, particularly people who've been civilly committed, adjudicated, incompetent. I mean, that language is horrible, but it's not just anybody with a diagnosis, right? The federal restriction is narrower than that. People have to process before they lose their right on that ground. And I'm just really, really hoping that we get to take suicide into account in defining what counts as dangerous. Because as a person with mental illness who's been in an inpatient facility, I don't want a gun. I welcome restrictions, right? Because I don't want to die, And so, that's my pitch on that.
Andrew.
Great. Well, thank you so much for inviting me here. I just want to echo the thanks that others have said to the Journal for organizing this great event. So I think this is really the perfect setup for what I'm going to talk about, which is that I'm going to be talking about Rahimi as well. Again, it's a sort of a late-breaking development. The court just heard oral argument on Tuesday morning. And you've already got some of the background my colleagues gave about Bruen, what the test looks like, and a little bit about how it's been applied in the lower courts since last June, and some of the confusion and sort of conflicting outcomes that we've seen. So I want to talk first about some of those bigger picture methodological questions and how those surfaced in the Rahimi argument. And then I'll get into a little bit of analysis about if the court is moving in these prohibited status restrictions, right? Certain groups of people who are banned from having guns towards a dangerousness test, which it seems like the court probably is. What does that mean for some other provisions of 922G, which is the federal sort of list of prohibited statuses? So, so first, I think as with any major change in constitutional doctrine, which I think Bruen certainly was, there have certainly been growing pains in the lower courts, and we've seen courts struggling with how to actually do this test on several different levels, some of which my colleagues have talked about, this question of the level of generality or abstraction at which you look at the history. I think is a constant one that's really difficult to provide clear guidance on. I think even saying that, the Supreme Court doesn't do a great job of Bruen, just sort of telling lower courts, this is what lawyers do all the time, go and do it. I think there's probably a little more that the court could have provided. And there's an interesting exchange at the Rahimi oral argument where Justice Kagan asked the Solicitor General, essentially, what guidance do you think that the Supreme Court could provide on for these lower court judges who are tasked with now applying a text, history, and tradition approach in the Second Amendment context? And the Solicitor General seemed to have this answer ready to go. She said there are 3 critiques or problems that in her view are the biggest problems with what's happening in the lower courts post Bruen. And so I'll just tick through those. Some of them will sound familiar because my colleagues have mentioned them. First, she said that courts in some cases are overly focused on enacted regulations or statutes when they look at the historical record, which I took to mean they're not in some cases not considering broader historical evidence things like secondary sources or treatises or other places we might look to find out what the historical tradition is. Second, she said that in certain cases, courts are requiring too close of a historical analog in order to uphold a modern law. This goes to the level of generality or abstraction problem, right? For example, in Rahimi, in the domestic violence context, you're not going to find a law in the founding era or even in the 19th century that bans domestic abusers from having guns, right? So you need to go up a level of abstraction. The Fifth Circuit, of course, did not do that. That's why they struck down the law. And finally, the Solicitor General said that courts are putting too much emphasis sometimes on historical silences, right? On the fact that historically a law may not have been passed and treating that, as Fred noted, as evidence of unconstitutionality, right? That because a law did not exist, because the law was not passed around 1791, that means that the legislature clearly thought that such a law would be unconstitutional under the Second Amendment. Now, of course, we know there are many reasons why a legislature may not have acted that have nothing to do with the Second Amendment or the Constitution, and so I think that's the point about these historical silences. So since Fred has already talked about that, I'm going to talk a little bit about this first issue, which is focusing on enacted regulations, potentially at the expense of or by excluding other pieces of historical evidence that might be relevant. And I want to just highlight sort of three metrics on which I think we can look at this problem. So first is geography or population. So the court in Bruen, and what I think is I still think is a pretty odd passage of the opinion. I've written about this, but the court basically says that there were laws passed in the territories, right? So territories in the West before they became states that were very broad public carry restrictions. New York relied on some of those laws and said, look, there is a historical tradition of restricting public carry. And the court said, well, these territorial laws are kind of unique. There weren't that many people in the territories. There are a number of reasons why we think we should disregard them for purposes of this test. And I don't think that's right. If you actually, if you think about the constitutional dynamics here, the territories are actually directly subject to the Second Amendment, right? So the 14th Amendment incorporates the Second Amendment against the states, so the states back in whatever 1820 or whatever would not be subject to the Second Amendment, but territories were subject to the Second Amendment all the time. And so if you're really trying to figure out original meaning, I think you do need to include those territorial laws. The second metric is time. So reading some of these post-Bruen cases, some judges are very narrowly focused on a certain time period, usually 1791, sometimes 1868. And I don't think that choosing one of those time periods is necessarily correct or required by Bruen. I think we should take a broad view of looking at the history from 1791 through 1868, potentially up until about 1900. That's what Bruen suggests maybe is the cutoff. I don't think that imposing kind of artificial limits on the time frame is that helpful. And finally, this is something that other scholars have identified as a possible issue, which I think is interesting, is the question of which entity is passing a gun regulation, right? So usually you would think of the government regulating firearms, but if you have something like a ban on guns in the subway, for example, in New York, and you're trying to find a historical analog, you might not. It might not be a law that was passed by the legislature, right? It might be a private railroad company that was saying, no guns allowed on our railroad cars, right? In the mid 1800s. So sort of expanding the scope of the inquiry to include private rules. Another context this may come up in is university or college firearm restrictions, right? Are we going to include private colleges in addition to state universities? So the second thing I want to do briefly is talk about this dangerousness test that also came up at the Rahimi oral argument. And as I understand it, the government was essentially proposing a two-category way of looking at these prohibited person restrictions, right? These laws that ban certain groups of people from possessing firearms. And the government says the first category is people who are not law-abiding. And that's sort of a misdemeanor felony distinction. If you are convicted of a felony offense, you can be disarmed. If it's something less than that, you cannot. And then the second bucket is people who are not responsible, which the Solicitor General at oral argument defined as having a heightened risk of danger tied to the use of firearms. So this category would be, this is where the domestic violence restraining order issue would fall. This would also be people who have mental illness would fall into this category. Minors or people under the age of 18, they're obviously could be law-abiding, but they're not responsible under this definition. And I think the questions of oral argument indicate that the court is likely to adopt some version of this framework. There are outstanding issues about how it would apply in a criminal context, right? You have cases where there is somebody who's convicted of a felony that doesn't necessarily indicate any type of dangerous conduct. I think the court's likely to take up a case to decide that issue pretty soon, so stay tuned for more on that. But there are also cases that could, I think, unsettle some preconceived notions that we might have about what dangerousness means, right? What does it mean to be especially dangerous with regard to firearms? So the second category. And there are a few of these provisions in 922G that I think fall into this category. One example is the ban on unlawful users of controlled substances possessing guns. This is a provision that's been in the news recently. It's what Hunter Biden is charged with violating. There's actually a cert petition pending before the court now in a case called Daniels, where again the Fifth Circuit struck down this provision in an as-applied challenge. So that's one example. Another law that I think is in this category of sort of being maybe on that outer bounds of this irresponsibility or dangerousness principle is the federal ban on possessing firearms by those who have been dishonorably discharged from the military. This is an interesting provision. It's one that's very rarely litigated, I think in part because dishonorable discharges are quite rare. There's one case from before Bruen where the Second Circuit upheld the law. It was using the old two-part tiered scrutiny framework that we've heard about today. And the court essentially, in that case, reasoned by analogy to the felon prohibition, right? So the court said, this is an individual, the individual in that case had been court-martialed and dishonorably discharged for committing conduct that would have constituted a felony had he done it as a civilian, right? So conspiring to sell stolen firearms and using drugs, the drug offense would have had a corollary in the civilian world that he could have been convicted of a felony. And so the court said, for the same reasons that the felon ban is constitutional, we think that this law is as well. And I think, the facts in that case made it a relatively easy one, but you can imagine situations where it's much tougher, right? There are things that you cannot do in the military that you can do as a civilian. You might, in terms of what could be the basis for a court-martial and a dishonorable discharge, things like insubordinate conduct, adultery, improper fraternization, right? Those could be the basis potentially for being dishonorably discharged. If you, by contrast, talk back to your boss, you're not going to be convicted of a crime, presumably. And the court did not deal with those issues, this question of the mismatch between military offenses and civilian offenses. The court did, in that case, specifically discuss some of the legislative history behind the Gun Control Act of 1968, which is when this provision was included in federal law. And it's interesting, if you look back at the Gun Control Act debates, there is a lot of discussion about three specific high-profile assassinations that occurred in the 1960s. President John F. Kennedy, Senator Robert F. Kennedy, and Martin Luther King Jr. Those are sort of animating events behind the Gun Control Act of 1968. And as far as I could find, only one of the individuals who committed those assassinations had a prior criminal conviction in the civilian court. So if you think about someone like Lee Harvey Oswald, he had a sort of discharge under questionable circumstances, and there's discussion of that during the debates about the Gun Control Act of 1968. So I think what that suggests to me, at least, is that we're dealing potentially with a different type of dangerousness when we talk about this provision. It's not necessarily the same type of dangerousness that we would see in the domestic violence context or in the felon context, where we're primarily concerned about civilian-on-civilian dangerousness. but rather there's a concern about a heightened risk of firearm misuse in a context with acute national security concerns and potential consequences such as a political assassination or an attempted assassination. And so I think that sort of throws a wrench into how we might think about dangerousness when we're looking at other parts of 922G. And I'll leave it there, but look forward to it.
Okay, well, be thinking about questions you might have. I, of course, have a few dozen questions of my own. So, I mean, it seems to me you could probably count to 5 for a current consensus view, at least if you read Kavanaugh's concurrence in Bruen for all it's worth. So I'm always thinking about that, in part because of my views about the Privileges or Immunities Clause, but also just because I think it kind of makes a lot of sense. I'm always telling students, or write me a 50-state survey of some issue. I'm like, oh, all the states? Yeah, all the states. I'm going to get a 35-state survey. So I'm always, when I was looking at what the SG said about this in Rahimi, I was kind of puzzled because she said, at the oral argument, it's clearly a fact she wanted to highlight. She said at least 48 states have laws like these. When I went back to her brief, to the U.S. brief, what the brief said is at least 48 states either allow or require a state court to do this kind of thing. And the brief didn't cite anything. So I was curious if any of you happen to know, I would think probably every state allows a court in a particular circumstance to disarm somebody if they include it in the restraining order. But how many states, are there any states that categorically do the thing the 922G, which one is it, G8 does? Are there state categorical bans?
So I can weigh in on this. I don't know the exact numbers. I do know there are state categorical bans, and that some of them are in fact broader than the federal provision, right? So some states, for example, as a default ban those who are subject to ex parte domestic contra restraining orders from possessing firearms. The federal prohibition, by contrast, applies only to orders that are issued after notice of hearing, right? So that leads me to believe that, and I don't know the exact number again, but there are certainly states that take an even broader approach than the federal government. I think that's part of what the Solicitor General is probably trying to say here. And it did come up in oral argument. I think the sort of way that this fits into the framework I was describing about dangerousness would be that you derive the dangerousness principle, right? If the court agrees that that's the principle, then, at least what the Solicitor General says in argument, is then you actually look to things like legislative consensus to see whether whether a legislature has acted within the principle.
I just don't see how the court's going to pull that off. I really do. They may, but then they just sort of cut it through. In that case, you might as well go back to, this one point, I agree that Bruen did a very bad job of telling courts how they were supposed to do these analogies. And in a piece that I wrote sort of critiquing that part of Bruen, I compared it to, you remember the episode of the South Park with the underpants gnomes? Where they find...
Step 2.
So the boys have to go figure out how corporations work, and they find this network of underground underpants gnomes that steal underpants as part of a business operation, and they ask them to explain their operation, and they're shown a PowerPoint slide that says, step 1, gather underpants. Step 2, question mark. Step 3, profit. And I think Bruen is a lot like when Justice Thomas describes how you're supposed to do these analogies. It's sort of like, step 1, consult history. Step 2, question mark. Step 3, decision. And the lower courts, the way that they've been struggling with this, sort of bears that analogy out. And if they're now going to go back and say, well, what we really meant was you can disarm dangerous persons. Well, then what has happened to history and tradition? Sure, there may be a tradition of disarming dangerous people, like Native Americans and people who refuse to sign loyalty oaths, but do we really want to, I'm not sure that those are the kind of historical analogies that we ought to be referring to, in terms of fashioning the right to keep and bear arms. And if you look at Justice Breyer's dissent, which was really quite good, and he's all sort of rueful. He's like, why didn't they just declare that it's strict scrutiny and we could be done? And it would be something that lower courts would know what to do with. And then just remand and tell everybody, okay, McDonald said the Second Amendment's a fundamental right. Fundamental rights usually receive strict scrutiny. Go decide cases, lower courts.
I think the way they might get to that idea is to say, okay, dangerousness is enough, but we're setting the bar really high in a way that feels an awful lot like strict scrutiny. You better show this person is really dangerous, and this law is really targeted to that danger.
Well, the other funny thing is the how and the why that Thomas talked about in Bruen. He said, well, it's important these analogies. It doesn't have to be a twin, but it has to be close. And sort of ask why the restrictions in place and how it restricts. Well, that's not means in scrutiny. That just with other labels, I don't know what is. So, it seems like that they've really just sort of painted themselves into a corner.
I have one other thought on sort of getting back to this question of why the Solicitor General might have made this point of saying 48 states do it this way. It's somewhat commonly believed, and I had a cite here on someone who wrote it up, or I thought I did, but I can't find it, but I'm happy to send it. But it's somewhat commonly believed that the court will declare a right to exist once that right has achieved some level of popular consensus that it should exist. And multiple people have written on it, but there's kind of a few famous writings on that point. And indeed, that's sort of a form of popular constitutionalism, right? And one can argue that in fact Heller was an example of this kind of constitutional adjudication. I hate applying labels to things because you can find exceptions and they never quite work, right? But Heller was decided in 2008 after public concealed carry had been around and spread to about 44, at the time 43, 44 states, something like that, right? Public shall issue carry. Even by then, and especially now, it was and continues to be a remarkably evolved social experiment. Right? There's no blood in the streets. When Florida was the first state to kind of set off this wave of shall issue licensing in the U.S. Before Florida, there were a handful of states. Alaska allowed it. Vermont didn't issue a permit. There were a few. But when Florida was proposing it, it was being called, said, oh, it's going to turn into the gunshine state. The Brady campaign was saying there'd be shootings at every fender bender and so on. And it didn't happen, right? Didn't happen. Other states adopted it like mad, and now permitless carry, sometimes it's called constitutional carry, is kind of the next wave of this experiment. And the blood still isn't in the streets from the concealed carry holders, right? So arguably, Heller came to pass because of this, because the social experiment, right, tacitly at least approved what could have been the outcome, and in fact was the outcome in Heller. And so I think that when the Solicitor General is saying, look, 48 states do it this way, I think she's appealing in part to this kind of social experimentation, right? That this is how it's done, and look, it works pretty well, right, for whatever reason. And, just so you know, there was a brief in Bruen that made a point of describing this social experiment on the concealed carry side, including in New York, California, and Massachusetts, where most of the state was public, in fact, was a shall issue state, right? The idea being, look at the rest of the state, it's shall issue. Why should the people in New York be discriminated in New York City and be discriminated against, when in fact the rest of the state does just fine without the look at work? So I think there's part of that, part of an appeal to popular consensus going on as well.
Okay, any question just over here?
This is pretty loud.
This is kryptonite, so how at least
Thank you. Professor, I forgot your name.
VARs.
Vars? Okay. We had a guest speaker last night that brought up mental health as kind of like the biggest challenge with Second Amendment and firearm ownership and stuff like that, kind of that big problem to solve to where, you know, both sides can be happy and stuff like that. And your comment about people with mental health issues being more dangerous to themselves than to others, how would you apply that as well to like mass shooter events and stuff like that?
Yeah, so I would say Rahimi is a great example. The connection between domestic violence and mass shooting much stronger than mental illness and mass shooting. That's not how it gets covered. And the moment a mass shooting happens, everybody, oh, did the person have mental illness? Well, yeah, and they also had a gun every time, right? So there is a misperception, a bias, I would say, discrimination, not out against people with mental illness. There's this false belief that they're dangerous to others, right? Are we dangerous to ourselves? Yes, absolutely. And there's lots of good data on that. But you do find, and I won't say that the relationship is zero to mass shootings, right? They're, you know, again, not as strong as domestic violence, but people with mental illness are overrepresented among perpetrators. I think there's a lot else that goes into that, right? That's correlated with having a mental illness, poverty, discrimination. I mean, a million other things, right? Is it the diagnosis that did it to them? I don't think so. I think it's, if you have that diagnosis, lots of bad things will have happened. Most people, well, many people with mental illness have childhood trauma, right? You dig into that and see the connection. So.
Also,
Professor Bars, I'm sorry to come back at you
That's
again.
all right.
Alongside with that, people with mental illness, especially when it comes to mass shootings, several of them have been children. We've experienced far too many school shootings to count. But one of the correlations between the school shootings is that these children aren't the owners of the guns. So at what point do we say, because you have a child with mental illness or you have a brother with mental illness, at what point do we cut it off and say, well, your entire household can no longer own a gun because your child has this, your child has that? A lot of these mass shootings in reality are not being committed by the people that are going through the lawful process of getting a concealed carry license.
Yeah, no, I think, it would be hard to go into a gun dealer and buy a gun if you're less than 18. They're not going to like it. So I think the answer is not take away the whole family's guns. It's gun safe, gun lock, smart guns can only be fired by the owner, like technology, and unfortunately, in some states do have safe storage laws. I don't think they apply to everyone. If there's minors, if there's a person with mental illness, you got to lock up your guns, right, for exactly this reason. And my understanding, I haven't looked at the data myself, those safe storage laws are pretty effective. And when I say effective too, mass shootings seem like, that's the problem with guns. That's like 2%, of victims, right? So it's just the non-representative tip of the iceberg. So the studies about safe storage, like injury and death to other people or the suicide by a minor, we can reduce all that by just locking up the guns.
One thing we may point out to help frame the discussion is that what's the percentage of the largest number of gun deaths are suicide?
Oh, by far.
Right.
It's
Yeah.
60. It's between 60% and 2/3 each year.
Yeah. And accidents are only 2%. And so one of the things.
It's less than 1%.
Yeah.
Exactly. It's in the hundreds out of some 40,000 deaths.
So one of the interesting things about the debate, and Brad and I talked about this, and I talked about it when I got to the law class, is if you frame gun control, whatever, some loaded terms on it. If you were to frame the debate in terms of suicide prevention, I think that that would be a great place for, but nobody's pro-suicide, for God's sake. I mean, but it would be a place where you could begin a dialogue between people who were skeptical of regulation and people who were in favor of more regulation. And the only way that this debate is going to mature and result in sort of productive studies about what is or isn't effective is if you build trust between both sides. And I think that coalescing around something like how do we keep people from shooting themselves when we know that if the number one successful means of killing yourself, what is it, 85%?
Oh, it's
90.
90.
Right. And number two, pills is 8. percent?
Yeah, less than.
I mean, if we were to could have that discussion, I think it would be a way that you could advance the ball in a way that talking about bayonet lugs and stuff, just hasn't to this point.
So I have to jump on this. So I came up with the idea to allow people to prevent their own gun sales. So attractive to someone with bipolar like me who's been suicidal, who will be suicidal again, I don't want to be able to buy a gun, but it will be voluntary. I will waive my Second Amendment right. And so we've actually had success in 3 states. We got in Utah, bright red state, enacted the measure, and it was Democrats and Republicans coming together. I mean, and in Congress, we had 2 Republican congressmen as co-sponsors, A+ ratings from the NRA, right? I mean, the NRA ultimately came out against it, but the members, not so much.
If I may, I'll just do a quick plug here on this specific topic. The Firearms Research Center that I run at the University of Wyoming College of Law next Thursday and Friday, is having a 2-day event on suicide prevention and out-of-home safe storage and gun owner firearm cultural competence, aimed at lawyers and practitioners who want to help these people, the FFL, federal firearms licensees who would provide out-of-home safe storage. We have an ATF person coming in. Professor Barrs was invited, and he wanted to come, but he couldn't make it to be one of our esteemed speakers. But if that interests you, it'll be streamed via Zoom. So you're welcome to send me an email or just go to frc.uwyo.edu, firearmsresearchcenter.org to register, and you can watch from here in Mississippi or really anywhere in the world if the topic is important to you.
I have a question about some of the federalism issues with 922. So, I mean, so 922G shall be lawful for any person. So I think in 1968 they had, any person who's been convicted in any court of a crime punishable by imprisonment for a time term exceeding 1 year. Okay, so Congress is coming in and telling states, it seems to me, hey, states, your sentences aren't long enough, or they're not severe enough. You need to add disarmament to your existing criminal penalties. And in the 8th question, the question about restraining orders, I mean, the restraining orders themselves could have prevented people from possessing a gun. This is the question that Justice Barrett asked, saying, if suppose the underlying order had said you can't possess a gun, would that have been constitutional? And the public defender sort of hemmed and hawed, but I think ultimately said, yeah. At one point they said, in the oral argument, said if you've written a statute just with 8 of the characteristics of Rahimi the man, and said we disarm somebody with all 8 of these, that would be constitutional. And Justice Kagan at that point said, aren't you conceding? But just in terms of the federalism thing, I sort of think, as a policy matter, why is this something the feds have to get into? Isn't this something that states can decide how severe the penalty should be? How in an individually tailored way, if you want to restrain somebody from ever seeing their acts, that's one thing. If you want to restrain them from ever possessing a gun, why not just leave it to the underlying state procedures?
Yeah, and I can start off here. I mean, I think the first thing I'll say is that my understanding is that the underlying family court order that was issued as to Mr. Rahimi did in fact say you cannot possess guns, and that's under state law, right? That's Texas law allow or perhaps.
I think it's saying he can't possess it in public, so he has to surrender his license.
I think that's part of it as well.
Okay, but they're essentially telling Texas they're not harsh enough on crime, which I mean, come on.
And I also think that, just sort of as an aside, that they, when they actually went and arrested Mr. Rahimi, they found this restraining order right next to his guns or something, right? So there's not a whole lot of questions about whether he was in fact within the scope of the ban here. But as far as the federalism issue, it's interesting. There was an argument in Rahimi's brief and by some amici, essentially saying that that 922GA and potentially large portions of 922G are outside the scope of the Commerce Clause, right? That's another basis essentially for the Supreme Court to affirm the Fifth Circuit in this case, because there is no this jurisdictional hook in the statute, which is how Congress has regulated this type of conduct, saying that it only applies to firearms that have traveled in interstate commerce, which is usually sort of a pro forma thing, that's too far. I've written a little bit about this. I mean, I think it would be, to me at least, a very strange case to tackle this question in, right? If you adopt that view, you're going to impact all sorts of other areas where this is the approach that has been endorsed by the appellate courts and by the Supreme Court for some time. But there certainly are those types of arguments that have been raised in the case.
Yeah, he's not a great poster child for the Second Amendment, and also not a great poster child for limited federal power. I think just not a great poster child. But it's a public defender case. They had a client. They argued with one of the circuit. Other questions? Oh goodness, we got a whole bunch from Little.
Okay, so I was just kind of briefly reading Gorsuch's dissent in Bruen, and he specifically talks about how he believes that the Supreme Court misinterpreted Heller in saying that they weren't using, or that they were only using, I guess, the historical context and rejecting scrutiny or strict or any type of scrutiny. Do you have any comments on that, or just in general?
I mean, that's ridiculous.
Okay.
He does try to retcon Heller and say that everybody got it wrong. But if that's true, then what the hell was the Supreme Court doing for 12 years, letting everybody get it wrong instead of stepping in and taking at least one case and saying, you're doing it wrong? And I think that the consensus, the near unanimity, sort of methodologically among the lower courts, it shows that to be completely just, gaslighting. I mean, really.
Okay. A few more there. Pass it down.
So, for Rahimi, poster child for what it seems like GA was designed to protect against. I was wondering if any of y'all had a comment on a petition that got filed last month out of the Third Circuit ruling. I think a guy who wanted to possess a gun pled guilty to food stamp fraud maybe 25, 30 years ago, and he was maybe seeking a declaratory relief that says that G1 violates Second Amendment. Seems like, at least from what I read, that he'd been responsible maybe since 1995 when he pled guilty to that state court food stamp fraud misdemeanor. And just because it was possible in Pennsylvania for him to get 5 years, even though he just ended up getting probation, he qualifies under G1's prohibition. So any comments from y'all about how the court might try to step out of the corner on that one, a more sympathetic party?
So that's so just to give the background for everyone. The Third Circuit said that Mr. Range, who had committed this fraud in '95, could not be disarmed. Disarmed. The word disarm means multiple things. Basically, disarmed forever, disarmed for life. For the various reasons you said, which essentially, in my mind, come back to him no longer being dangerous. There's the danger word again. There's an article out there entitled "Why Can't Martha Stewart Have a Gun?" The idea being that Martha Stewart committed federal felonies, not insider trading. They couldn't get her on that. She lied to government agents and so on. Spent some time in jail, and that was a felony. And now she can't, for the rest of her life, she can't have a gun. And the article was questioning that. That possibility. Does that make sense? I think if the court goes with a dangerousness standpoint, it sets up the Range case very easily to just deny cert, and then it won't go anywhere. Actually, right? I'd be surprised if cert were granted on that case either way, because in fact Mr. Range is not a threat. He's been somewhat of a poster child since '95. He got some tickets or some things like that, but it's basically just a good citizen, whatever that means.
It's okay. Yeah, well, I think that charge would be as applied. The statute would still apply to like violent felonies or kind of real felonies. And one thing I wanted to push back a little on how deferential to Congress lower courts were under the old standard. So there was an as-applied challenge to the mental health prohibitor in the Sixth Circuit, and actually cited that article about mentally ill have a right to bear arms. And they decided that as applied to a guy who had been hospitalized years ago, wanted to get a gun, decades, not probably really much more dangerous anymore. And the government was able to cite a study of people who had been involuntarily hospitalized and show in the year after hospitalization they have a 57 times likelihood of suicide. Right? Again, not violence towards others, because that really isn't there. And the Sixth Circuit, upheld the as-applied challenge and said, well, it's 20 years and your study is only for the first year. To me, that's not giving a lot of deference to Congress.
Not at all.
Yeah.
I agree with the Tyler case, right?
Yeah,
The Sixth Circuit went en banc to do that. The panel ruled against Mr. Tyler, went en banc, and the en banc court ruled in favor of Mr. Tyler. So that was one of the exceptions. There were a few out there. It's got a kind of a sad story. Not sad story, that's not the right word. An unfortunate story. Mr. Tyler ultimately just gave up. He was just too old and he stopped prosecuting the case. And I forget why that was the case after the en banc court ruled in his favor, but somehow he still couldn't get the guns because of something that happened. I don't remember the details. And he just gave up. He'd been fighting the case for years. He was in his late 70s, and so just said, I'm done. I can't do it anymore. I can't fight the resources of a government that wants to just continually throw one thing after the other at me and not let me buy this shotgun or rifle or whatever you want.
There is, I think, still a statute authorizing ATF or the FBI to give you dispensation if you apply, like an administrative remedy.
Yeah,
but that doesn't work in a lot of states.
Right, and so what happened is, there's that federal provision that says exactly that, but Congress has explicitly defunded that, so no federal money can go to that. What still works is if your state restores your rights for you. Now, not every state will restore your rights, not every state has a procedure, and some of the state rights restoration procedures aren't good enough, and I don't know the reasons why for that. Maybe you guys know the details, but they're just not good enough for whatever reason, and so they don't work. So for some folks, it's just nothing they can do about it.
Just really quickly to sort of bring us back to the range case. So George described the facts a little bit. I was looking back at it the other day, and the facts are even actually more sympathetic. So it wasn't even. I think Mr. Range himself didn't even prepare the application. It was his wife, and he sort of just said, "Yeah, I should have known. I should have gotten my income right." So I think that it's quite likely that the court will ultimately take that case. It actually came up briefly at the Rahimi argument. Justice Barrett mentioned the case by name, and Justice Barrett, when she was on the Seventh Circuit, wrote a dissenting opinion in the case, essentially saying that somebody who was in Mr. Range's position can't be subject to a gun possession ban with that type of nonviolent felony conviction. So it'll be interesting to see what happens in that case. Having listened to the en banc argument at the Third Circuit, one of the big challenges is how do you figure out what sort of an as-applied only system looks like, right? Like do you do it based on the elements of the offense? Is there a factual determination that's necessary in every case? There are going to be a lot of difficult sort of edge cases of crimes that people might think are dangerous or violent. Some people might feel differently. So that's a tricky issue to sort of.
Yeah, I was going to say, Justice Barrett, when she was on the Seventh Circuit, she had a case it was somebody who had defrauded Medicaid of reimbursement money related to podiatry implants for shoes. So I was podiatry fraud. It's not the kind of thing you think is super dangerous. And at the Rahimi oral argument, I thought it was very clear that the SG knew that about Justice Barrett. It's like, well, Justice Barrett, I understand you may have a different view, but I'm trying to get get some of the other aid. Other questions? One big thing, I mean, we talked about kind of an as-applied only regime. It does, in a world without Salerno, so Salerno is this case from 1987 saying if a statute is constitutional, even as to one application, you can't get facial invalidity. Facial challenges to laws are extraordinarily hard to win under that. And, you know, there was some language in Bruen, if you think like, oh, well, you know, it's gotta be, you know, that kind of statute, you know, really old, not just an application. So, you know, in the abortion jurisprudence, there were a few cases. There was a case from 2000 that sort of suggested that abortion was a Salerno-free zone. And Bruen, you know, I think maybe the Fifth Circuit, you know, not completely unreasonably interpreted Bruen to be saying, well, maybe, you know, the Second Amendment is a Salerno-free zone. And Justice Gorsuch, I think, at the oral argument, they're like, no, what are you doing? You know, this guy is dangerous. You know, it's constitutional doesn't apply to him. Any thoughts about, you know, just the future of Salerno? Are we back to, you know, facial invalidity being only a kind of weird First Amendment thing?
I would say one thing. The substance of Salerno is what I find interesting about it. And the idea is we can deny you bail if we think you're dangerous. No, you don't. I mean, I guess you get a bail hearing, right? Or you get to make your case for pretrial release. But essentially, it's like one of the broadest applications, and a demonstration that the government can look at you and say, oh, well, a prosecutor filed a charge. And pretty much that's it. We can deprive you of all your liberties. We're not going to take your gun to jail with you. You're done, right? Until trial.
And you're technically innocent. So,
Yeah,
but it was this is my introduction to the law when I was in high school. I learned about this for prison overcrowding debate topic. And Tony Salerno, this guy in the mob, was, it's a little bit like Bohemian. Like if the government is defending preventive detention of people, you're based not on flight risk, not on, he's going to come to trial, but just purely based on dangerousness. I mean, Tony Salerno is who you want, and and then Chief Justice Rehnquist said, now I'm getting a chance to put the kibosh on facial invalidity and have this language saying it's constitutional even as to one one person. I'm talking about you, Tony Salerno. You can't have facial invalidity. So I don't know if Justice Gorsuch is kind of leaning that way, but it certainly seemed like it. Anything else? Thank you all for coming. We look forward to seeing how Rahimi comes out and seeing future scholarship in the journal on this topic. Let's give our panel.